Lucy just asked me, what do you normally talk about? Yeah, I'll have to know it. Sorry.
Stephen, do you hold any prospecting this afternoon? I don't mean that as a criticism, just sort of thinking of planning.
Love your work, brother. She sends me an email. What five prospect?
Well,
Hey,
I
Shelley.
can't stay in Darwin. But
What do you think about us saying finish?
but I think that's the way to do it. I mean,
Yeah, all good, all good.
I can obviously
Thanks, Shelley.
buy this afternoon, but I don't particularly want to be finished.
She sends an email and goes, hey,
Whatever. I'll obviously do what's necessary.
I'll canvass with her
Yeah.
how fixated she is on not finishing when the fact that MRM are going to have some,
Some further opportunity. Yeah,
I doubt they will want to.
I know.
Do something or make any application they want to make. So,
Albeit-
might therefore not be particularly troubled.
Yeah, I doubt she will be troubled. I think it makes sense to complete the submissions before we get onto the MRM process, in a sense of trying to get them done next week.
That was so computer. Computer?
You mean in terms of days next week?
Same with my computer.
Wednesday and Friday I can do. Could probably do Tuesday.
At the moment, I think it should go away. I could do Tuesday. So if you want to take how about the following week? The following week is that going to be much? Wednesday or Tuesday, okay?
I see the point about preference in person because licenses, I don't have any from person that does feel like it's proportionate.
Silence, all stand. This honourable court's now in session. Please be seated.
Yes, Mr. Lloyd.
Thank you, Anna. Before I start, I've had some discussion with my friend. We're not entirely confident that we will finish today,
I am.
especially with his reply.
Sorry, I'm entirely confident that we will finish today.
See. Okay, well, we'll work towards that direction then, Anna.
We'll see how we go.
Can I take you to Padovan affidavit number D4?
Okay. That
was in the key documents folder handed up yesterday.
yes. Yes, have you got 'em?
Have that?
I will in a minute. Thank you. No, the Padovan affidavit dated what?
26th of September 2022.
Thank you. Yes, and that's D4, you say?
D4, I believe. So there's a reference at 117, paragraph 117, to a letter called the Recommendation 12 letter.
Yes?
That's a letter that Joanna saw yesterday, a letter from my client to the NT-EPA. I won't take Your Honour back to that. But then I note in paragraph...
When you say your client, is that the minister or someone in the department?
Someone in the department.
Okay, department to NT-EPA, yes?
It is P18. Just for the record. So the Recommendation 12 letter is P18.
Yes?
Then in paragraph 119, there's a reference to that letter providing a copy of slides that were presented to the Department of the Environment on the 4th of June, the 4 June presentation. Do you want to see that? This is paragraph 119.
Yes, just finding it. Yes?
And that presentation is in our bundle. I won't take you on a tour because it is almost exactly the same as the presentation to the Minister, so I would make all the same submissions about it. But
Yes.
I can give you a reference to it.
It's in D5 at...
You have 107.
Thank you. Yes.
Then I note in paragraph 120, says the Recommendation 12 letter sets out the rationale behind the approach to deal with the TSF is unplanned, with the TSF in unplanned closure. And
you've summarised the letter there.
I've summarised already the reasoning behind that in submissions to Your Honour, but I draw attention in particular to paragraph C there. Then I draw attention to paragraph 122. I understand the officers of the Department of the Environment provide services to NT-EPA, and it was in that capacity that they attended the meeting on the 4th of June. So that's Mr. Padovan saying he had a meeting with officers who are formally employed by the Department of the Environment but are servicing the EPA. And then during that meeting, after having had this presentation, and the presentation says, as I indicated before, we've got a problem with putting the tailings in the pit because the pit's not deep enough yet, all that stuff. He says, during the meeting I inquired whether any further notification to the NT-EPA was required and advised that it was not. So we say that there was correspondence or engagement with the NTEPA about whether or not my client's approach to Report 86 was adequate, and that is effectively the EPA officers saying no further action required. So that is the point I was making before lunch. I'm just trying to remember where I was. That was one side issue, but I think I've covered that. Let's see if I finished off looking at that presentation to the minister. Oh, yes. So I think I was at about page 645 in tab 29, which is the slideshow to the minister, but I'll make the submission that it's very, very similar to the slideshow that had earlier been given to the EPA representatives, but at least in the regard that I've already addressed. But then on page 646 of tab 29, there is a reference there to the minister, in the minister's presentation, to the independent security auditor, Fronis, and in the last dot point on the first frame on 645, to that being a reasonable, that the Fronis opined that MRM's estimate was reasonable.
Reference to independent security, did you say auditor,
Yes.
who said that the operator's estimate was reasonable?
Yes, so one sees that in that quoted bit in the presentation to the minister. Now, the point of all of this is we will say that calculating an appropriate security is a technical matter. The minister's entitled to take advice, and she's got a submission, as it were, from the operator. She's got a submission, or at least a view, as it were, from the department. The department's view was lower than the operator's view, and then it's been sent off for an independent person, and that view, we say, or the fact that there is that process, first of all, a process with an independent auditor, and then the independent auditor says that the assessment is reasonable, then that is all sort of grist to the mill of whether what the minister did was reasonable in accepting the security calculation. Then a bit further down from 647, and I won't go through them in profound detail, but one sees at 647 there's a table that says NT EPA recommendations implementation status. And so it goes through each of the recommendations and explains how they're being implemented in the proposed new authorisation.
Yes.
That is consistent with a claim of consistency, we say.
Mm-hmm.
So that, I think, is all I wanted to say from that document. So if I can take your honour now to the mine management plan, which is back, it's in volume 2, tab
130?
19.
Oh, 19, all right. Thank you. And that was
I'll find it out.
P6.
P6? You might. Thank you. So, and then to page 335, which your honour has seen before. It's the part of the plan which deals with closure planning.
Yes.
So, in that passage under 8.1 through to the bottom of the page, we say that the plan, the mine management plan, identifies that the MMA expects a security be taken for mining activities that are authorised, and the unplanned closure plan is Appendix P. You can see that just before the 8.2. And if I can go to that to then explain how we say it is to be understood. So that is at volume 4, tab 57. P7. I can start on
P7, and what is that? Tab, what is it? Volume 4, tab what?
tab 57.
7, okay. Is it in here?
And to go to page 2195.
You got that, Lucy?
Say,
I don't seem to have it though. Oh, yes, sorry, I've got it. Yes?
now on 2195, there's a heading scope and purpose. And in the second paragraph, it is made clear that the UCP is used, at least one of its uses, is in the calculation of the security. UCP and the security calculation reflects the activities proposed in the following year. So not that it has to be done in the following year, but it's proposed for the following year. The security is calculated by reference to the level of disturbance, we say, from mining activities proposed for the following year. Putting it another way, the security is not calculated by reference to the mining activities that are expected to occur after 2020, but that are proposed, in the list of things that are in the table, which my friend took the court to yesterday, in table 2, which is on page 2207. Starts on page 2207.
Yes.
It's referred to on 2207 and then starts on the next page. And so that has a list of things. And if one looks, for example, at the third one on the list, open pit development. So stages I, J and K are planned to continue to be mined in 2020. But then there are other stages, and in one of the maps my friend gave you, there's a list of the stages. I think they go up to stage M.
Correct.
So, anything other than I, J and K is not the subject of the security. It's not a key activity that's proposed, therefore it's not the subject of the security. Therefore we say it can't be carried out under the authorisation. yet. I mean, that's why I knew
Even though the authorisation doesn't specifically say so, you say that that's so by implication from the requirement in the, for the requirement for there to be a new unplanned closure plan in the year and the condition of approval that every condition must be complied with, including that one.
yes and no. Yes, it does say that, but we say it also says it expressly in condition 12.
Okay, also condition 12.
I'll come to that shortly.
You say anything other than planned key activities 2020 not authorised because
Or can't be done consistent with the conditions. You can't undertake them, you can't carry them out. To carry out any activities other than those that are planned for 2020 would be in breach of condition 12.
cannot be carried out or it would be a breach of condition 12.
So then, I won't take you over to this, but at tab 59 we see the signed version of some of those documents I've already taken the court to. That's P8. At 2347, which is P9, is the signed documents of the Statement of Reasons. I won't go back to that.
Yeah. Perhaps we could, I'm sorry, Mr. Lloyd, but we are going to move on. Perhaps rather than telling me what you're not going to take me to, we could sort of just go from ones to ones. I mean, the ones that you are relying
Certainly.
on. Given the time constraints that we have.
Certainly. So, I think. So I might go to the authorisation,
Yes?
which is tab 61 in volume 5.
What exhibit number is that?
P11.
E11, yes, thank you. Yes?
So maybe if I start, I'll go backwards and forwards a little bit, but start at
Yes?
so condition 10 requires the provision of the security before any authorised mining activities can be undertaken. So that's the first element of it. Then condition 11 makes provision for further changes to the security requirements in certain circumstances, including an amendment to the UCP. And then condition 12 says the revised security amount to be provided under condition 10 is to be provided prior to creating the new disturbance covered under the revised security as per written notification to the department. For the avoidance of doubt, the operator must not provide the revised security amount in the form of cash or in an unconditional bank guarantee. So an operator is authorised only to undertake an activity that creates a new disturbance to the extent that the activities are, using this word, covered under the revised security. So you are covered under the revised security if you're one of the planned, if an activity is covered, if it was one of the planned activities for 2020, that led to it to be covered by the security. If you were something which was planned to be done later than 2020, you weren't included. So we say that condition 12, properly understood, means that the only activities that can be done, that can be carried out under the authority are those that are covered by the security that's been taken. So you can't do anything else that hasn't been planned. So that's how, you know, asked me before,
Yes,
that's how we say we
you
get
say it's
to there.
express.
I'm not saying that it couldn't be clearer, but that's
No, I
how we say
understand.
it works. Then if we go back to condition 4, the operator may only conduct mining activities identified in the MMP within the mine, subject to the conditions contained in this Act, this document, and the conditions commitments. So that operates in conjunction with 12 to say if it's not consistent with the conditions, you can't do it. And so we rely upon that as well as working with 10 and 12. And I draw some attention to condition 6, the operator on 31 August and on each anniversary of that date, review the approved MMP and if necessary amend the MMP. So there was some question as to whether that had to happen, so there is that provision as well. Then going to 99. On the date of authorisation of the burden, that means really the date of this authorisation, November 2020, the operator must annually submit to the Department of the Unplanned Mine Closure Plan on or before 31 August starting 2021 to the department, which is accompanied by the related security estimate. So there's no, the following year, I think my friend said yesterday it was done in March of 2021, well before August of 2021. There was no breach or no failure to do what was required to be done. They did put in further plans, they did seek a little bit of extra approval, and then as a result the security was increased a bit to allow the extra disturbance activities, we say. Then a few other matters to note. On page 2362, so sorry, that's back again.
Say that again, page what?
Page 2362, I just draw attention to a few other aspects of the conditions which pertain to different things. So there is this explanatory note. I just draw attention to the second paragraph of that note, which identifies the overarching environmental object to be achieved by the mine is the protection or the health of the MacArthur River. And I draw attention also to condition 21. The operator must fund an expert panel to advise on TSF, NOEF and mine closure planning. Now that's important, that's also a recommendation of the EPA, because the situation we say is, at the moment, well, even the EPA recommended this because the EPA said you'll need to, as things develop and you learn more about the overburden and the like, you should have an expert panel that should advise you on developing a longer term, a longer strategy plan. And so that is being done. And so that's why we say you can have a short-term plan or an unplanned closure plan, which deals with a more immediate closure possibility, with a view of developing a longer-term plan, and that's what's envisaged here. And I probably should have mentioned when I was at paragraph 11 condition 11, that it's not just a matter of the MRM bowling up a UCP and meeting the requirements of condition 99. Under condition 11, it has to be submitted, assessed for approval. So it's the whole process. It's not just some kind of simple mechanism. Then I draw attention also to conditions 24 and 25. They are conditions which show that, and they parallel aspects of the EPA recommendations, to work towards having the tailings in the pit void. That
Just let me make a note of that. Yes,
24 and 25, and then I think finally for the authorisation, 96 to 98.
96 to 98.
So those conditions also address the sort of what might be called a final closure plan and can be distinguished from the shorter term unplanned mine closure plan.
Wait on. If you could just bear with me. You say right, you say that working towards the long-term plan or the final plan. Is that what you
Yes,
say?
so in the same way as condition 21 requires you to appoint some experts and develop a process which is a final closure plan, this is more focused about that. So by 5 years prior to the cessation of mining,
You've got to have your final plan in.
you've got to have your final plan by then.
Yeah.
I don't know that anything flows from it, but in relation to 96, it says the operator must submit an updated mine closure plan with each MMP, not every MMP, but each MMP that builds upon the closure concepts defined in the overburden management project. So if you're developing something significant, then you have to do that. That's when an updated kind of final mine closure plan would be required. That's to be distinguished from 99 when you're just doing, asking for approval for some more activities and providing security for some more activities.
In addition to having a new unplanned closure plan every year, every time there's something significant that touches upon the closure concepts defined in the overburden management project, then you have to do another updated closure plan.
You have to do an updated mine closure plan then. So it's not every time the MMP changes, but if the MMP changes in a way that builds upon the closure concepts.
Yes, I got that.
So that is likely to happen when this panel has been developed and they start, recommending things. Now, before going to the grounds, I just want to address some things said by my friend yesterday. Mr. Jones said that it was common ground that the security was calculated on the basis that the mine would close at the end of 2020. That was how he put it, but that's not how we put it.
No, I understand how you put it.
Thank you, Your Honour. Now, the plaintiff suggested that requiring annual reviews of the UCP under condition 99 was random. We say it's just a sensible way of administering the scheme. It's not arbitrary
No,
in that sense.
The randomness was the 10 years. That's what he was talking about. Those dates were randomly chosen, Mr. Jones said.
I know
There is evidence that, this is his submission, there was evidence that a monitoring was required for 100 years, and yet the plan, the unplanned closure plan, randomly chose 10 years. You're going to tell me that wasn't random, there was a good reason for it.
That's true, but the bit that I was talking about here was, I don't know, my notes had him at some point criticising condition 99 as just being, you know, as sort of randomly deciding there should be one every year.
Oh.
We just say that's just an administrative choice.
Yes.
And at one point, Mr. Jones submitted that a successful closure, that's an idea in the closure certificate provision in section 46, is a closure that the mine could never, he submitted that a successful closure of a mine could never be an unanticipated closure. We reject that. We say a successful closure of mine is one that satisfies the minister under section 46 and results in the issue of a certificate. The importance of that, and this relates to other submissions made by my friend, is that when that certificate is issued under section 46, that is the end of the relationship between my client and the miner. At that point, all of the security is paid back. And that has this significance,
Yes.
that the word post-closure, in the context of post-closure monitoring, needs to be understood that it's not talking about closure of the mine site, it's talking about closure of the mining or extraction processes. And so when it talks about monitoring post-closure, it's saying after you've stopped mining and you're starting the rehabilitation work, there will be monitoring for a period at that point. And the idea is, however long the period, whether it be 10 years or whatever, you do your rehabilitation and you monitor it so you can show the plants have grown, the water isn't seeping away,
I understand.
all of that stuff. But then critically, and I think this is where I might differ from my friend, it is only at the end of that that you get your closure certificate.
Yes.
The closure certificate happens, and that's when you get the money back.
Yes.
So if there's 1,000 years of monitoring,
You
as my
get your
friend
money
put it,
back in 1,000 years.
you get your money back in 1,000 years.
Yes. I understand that.
I just want to make sure that that was clear, because my friend submitted contrary to that.
No, I didn't understand him to submit contrary to that. I understood that that's exactly what he was saying.
Okay, well, that's fine, then we're in agreement. And so what we are saying when one's looking at the extent of monitoring, you're talking about monitoring that you would have to be done to reach the satisfaction, a state of satisfaction under section 46, that, you know, the place is rehabilitated to the extent.
Well, where you get that from is from your closure plan, isn't it? If your closure plan says 1,000 years, well, it's 1,000 years. If your closure plan says 10 years, it's 10 years.
But
And that's a closure plan that's approved by the minister, and then presumably the minister reaches satisfaction that there has been a successful closure when all the criteria in your closure plan have been met, and then you get your money back. Wouldn't that be correct?
Yes, that you get the section 46 certificate when the minister is satisfied that the closure plan has been brought to an end and
Yes, exactly.
you've successfully done it.
Yes.
Now, one
And
of the
what you
things-
need to successfully do to satisfy the minister will depend on what's set out in your closure plan. And if it says 10 years, it says 10 years. If it says 5 years, it says 5 years. If it says 100 years, it says 100 years.
And if it says, for example, and this is one of the things my friend took the court to, that he wants a result that the land will be safe for animals and humans for 1,000 years,
After 1,000 years.
100 to 1,000 years, That is also, we would say, in practice,
I'm not sure that anybody said for 1,000 years. It said they would monitor it for 100 years and then another place 1,000 years in order to be assured that it is safe for humans and animals. Not that it's going to be safe for humans and animals for 100 years or 1,000 years.
well, we say that the objective is to, well, the closure objective would be met if the minister was satisfied that the land would be safe for animals in that range to 1,000 years. Now,
If that's what the plan says.
but that doesn't mean you have to monitor 1,000 years. That's the objective, that the minister has to reach a satisfaction about that. But he could do that.
If that's what the plan says.
Certainly. But if he could do that on the basis of 10 years of monitoring, then he can do it on the basis of 10 years
Yes,
of
but
monitoring.
if the plan says we will monitor it for 1,000 years, that's not the same thing as saying I need to be satisfied that it will be safe for the next 1,000 years. There's a difference.
Certainly.
So all my point is that if you want to find out what successful closure will be, you look at your plan.
Yes. Yes, but just so long as we're clear that that
A plan will speak for itself, will it not?
exactly. So I'll now turn to the four grounds, Rona. The first ground is the section 43A ground, that is that the minister's alleged failure to calculate security by reference to the life of the mine. Now, I've already made a number of submissions that I'll be relying upon, but it'll be apparent that the plaintiff's case, I'll withdraw that, we say there's nothing in the Act that refers to the life of the mine. There's nothing in 43A that refers to the life of the mine. It refers to mining activities to be carried out under the authorisation. We say that that means in accordance with the authorisation, by which I only mean to say not inconsistent with a condition in the authorisation. So if you can carry out an activity that is authorised in the sense that you are allowed to do it, then that is what 43A1, the language naturally means, to be carried out under the authorisation. And if there's a condition in the authorisation that says you can't do it, like we would say is the effect of conditions 10, 12 and 4, that if it's not in the proposed for 2020 category, then you're not allowed to do it because a security hasn't been taken and you can only do things for which a security has been taken, then it can't be done. And in that way, these two ideas mesh so that 43A, in the context of this case, is satisfied because the unplanned closure plan and the authorisation allow to be done those activities that were taken into account for the calculating of the security. And we say that there is no breach of section 43A in respect of that, and that Your Honour should reject the notion that there is some implied or otherwise life of the mine type notion. I accept that Justice Southwood in a couple of locations does
Well, he
say something.
explicitly said that in a number of locations, but you say, well, that's overturned.
He didn't have a case, for example, which had conditions 10 and 12 and 6, so he just didn't have to consider these issues. And absent textual support for the proposition, they should be rejected. We say that the applicant's written submissions, and so far at least their oral submissions, have failed to really address the condition 12 point that we make.
Yes.
And if I can just give Your Honour an example of how we say that works. We give some examples in our written submissions from 25 to 34. I'll just go to one of them so Your Honour can see that it's not a
Sorry,
kind of,
written submissions, what paragraphs? I just want to make a note.
25 to 34 of our written submissions.
Yes,
We give several examples. The one that I'll be going to is at 25 and 26. The mine management document, which is tab 19, at page 240, shows the different stages of the pit, the I, J, K, M, I think, on page 240. Your
Yes.
Honour has that as a big map in the
yes,
bundle of maps.
I recall that.
That I mentioned as I was going through the third line on that table, table 2 in the unplanned closure plan. It only included I, J and K.
Yes,
So we say that the effect of conditions 12 and 10 and 4 is that any disturbance that would be caused, say, mining stage M, has not been the subject of the security calculation. Therefore, any of that work has not been or couldn't be carried out under the authorisation.
yes,
And so
I
we say
understand that.
that's a kind of a practical issue. Now, I've probably said all I need to say about Territory Iron, but I did want to just draw Your Honour's attention to paragraph 83 of it.
I got that. Oh, have you got it? Oh, you got it, thanks. 83, yes. I have it.
So, His Honour says no mining activities included in an amended plan can be commenced until it is approved by the Minister. Logically, the security is to be reassessed when an amended mining plan is submitted, and this will involve an assessment of the level of disturbance likely to be caused by the mining activities to be carried out under the amended mining plan. Now, we say that that is essentially what we're doing. In that sense, it's not really inconsistent.
No.
I accept that it's inconsistent with the life of the mine language. It's not inconsistent with how he sees the scheme as actually working in a practical sense, except that we're only allowing, through the use of conditions 10 and 12, sort of an iterative step-by-step
Yes.
amount. And so we say there's at least a view in which one can say our position isn't even inconsistent with the obiter fully understood by His Honour.
Because it's a different factual
Yes.
situation.
That's what I say about ground 1, or issue 1. Issue 2 is the security calculation grounds. This is the arbitrary end dates for monitoring.
Yes, you were going to show me that those arbitrary and that those, the 10-year dates were considered and not arbitrary.
Yes, or how I'd put it is, I'm going to try and persuade Your Honour that Your Honour shouldn't find that the selection of those dates was unreasonable, and that on the evidence before Your Honour, you shouldn't be so persuaded. So we say the plaintiff puts it as a very merits kind of way of putting the case in how the security amount was calculated. I'll turn to those shortly, but to see how the case is actually pleaded, in the third further amended originating motion, there are 6 grounds that all fall under this issue. Grounds 5 and 13 contend that the Act makes a mandatory relevant consideration, quote, the full post-closure monitoring and maintenance costs. Now we just say, the Act doesn't say anything like that, it just doesn't say that. Then at paragraph 72 of their submissions, they say that they break down, is how they put it, that ground into more specific matters. I'll come back to how they put that then. Grounds 6 and 14 contend that the minister acted unreasonably or irrationally in calculating the security. That ground is sought to be made out by identifying a range of factors that were mostly included in the calculations, but not in a manner that the plaintiff considers should have been done. It is, we say, a merits attack masquerading as an unreasonableness challenge. And then finally, the plaintiff in grounds 6A and 15 contend that the security calculation tool perhaps fettered the minister's discretion. We say that that is a very difficult argument to advance. My friend, even in his submissions, refers to them as suggested inputs. The tool itself refers to it as a guide, and it says that you can adjust the form as necessary. I think my friend during his submissions, at one point yesterday, I think said he didn't make the same submission about one thing as opposed to another because he accepted that in relation to the second thing, the MRM had created a whole new page for that. So they obviously knew they could do that because they made new pages. That is uncontroversial. So we say the idea that it's a fettering of discretion is extremely weak. So in substitution of those pleaded grounds, the plaintiff asserts that there's a requirement of the Act that precluded the use of monitoring and maintenance end dates, that's in paragraph 72B, or failed to include certain costs that the Act required to be included in 72C. Now, I've already taken, Your Honour, to the Act. We say it doesn't, in terms, mandate those matters in the calculation of a security. It makes plain that the taking of a security is a practice designed to facilitate best practice environmental management of mines. It does that by empowering the minister to take action to clean up the harm under Section 83. It makes the cost of doing so a debt, and then that debt can be used to engage the security, make a claim on the security. It has a scheme under which the minister can recover her costs by making a claim under that security. Now that all creates an incentive for the miner to run the mine as efficiently as possible to minimise the rehabilitation costs or to keep them to the lowest amount because the miner will be liable for them at the end of the day. The only constraints, we say, on the calculation of the security on Section 43.2, the purpose requirements, and 43A1. It may be accepted that the minister must not irrationally or unreasonably calculate a security, but we also say it is clearly an expert technical undertaking. I don't think anyone suggests that the minister personally did it, nor that the minister, for example, looked at the length of time of post-closure monitoring or whether there was an entry for the S prod or the W prod. Those are all things that are at a level of detail that the minister clearly didn't look at. The material before her shows.
And you say if the department made a mistake in making, leaving something out, or did all this or what have you, what it is a mistake in the calculation and it's a factual error and it doesn't go to jurisdiction at all.
Well, it doesn't go to unreasonableness.
Either unreasonableness or jurisdiction.
Indeed. That is...
Well, because both were put against you, weren't they? That if you hadn't done it in accordance with the section, then that goes to jurisdiction. And if you've done it flagrantly, wrongly because there's 1,000 years required and you put in arbitrary 10, that's unreasonable. But you say, in any event, if there is a mistake in this quite complicated technical process, it's just a mistake and it's a factual error. There's no merits review, it's not unreasonable and it doesn't go to jurisdiction.
That is so, Your Honour. The minister in this case she was given two estimates, the department's estimate and the MRM's estimate. She chose the higher estimate, nothing irrational about that.
No.
She had, we say even if the advice was wrong, that doesn't reveal unreasonableness.
No.
It's rational to take advice from sources, especially when one has an independent auditor to kind of back it up. And now, I want to also draw Your Honour's attention to something I don't think has yet been drawn attention to, is the contingency amount. There's something called a contingency.
Yes.
So that can be seen in tab 23 on volume 2. I thought it was tab 23, but I think that's wrong. Oh, hang on, I'm looking at the wrong one. Sorry. Sorry. It's P15, Your Honour, the large, the matter that my friend handed up this morning. So Your Honour will see I should probably, while on that point, draw Your Honour's attention to the pink words at the top of that page. That's relevant to the fettering argument. But Your Honour will see that basically the way this works is there's an identification of expected costs, or however one expresses that, estimated costs of various things, and that's done in categories 1 to 9, and then there's a decommissioning and post-closure management amount. That leads to a subtotal for all domains of 386 million. Did you want to see that?
No, I'm just taking your word for it. All right, got it? Yes?
Then on top of that,
There's a 15% contingency.
there's a 15% contingency. So
And then there's a 10% discount.
the discount is offered apparently because they all have to pay a levy. So
Okay, so,
in
yes.
return for the levy, they get a discount, apparently. But in any event, even when you see the contingency is 10%, 5% or 15%,
15%,
there is an additional amount on top of all of those things, which is in a not insubstantial amount. Now, in terms of what that contingency amount is, if I can take Your Honour, not the quantity of it, but the nature of it, to volume 5, tab 82.
Is that exhibited already?
Your Honour. The Department's advisory note titled Security Calculation Procedure. I don't think so.
Are you going to, or is it in your bundle?
Now, it should be in our bundle. On
Volume 1 or 2?
Volume 1, I'm told.
Yes, I have it.
Now on page 2591, heading 8, Release of Security. Under that,
2591.
2591. And it explains something about it. A partial security may be released back to the operator on provision of evidence that demonstrates adequate rehabilitation has been undertaken. This is a discretion. This may require a site visit by mining officers to verify that planned rehabilitation has been completed. But then relevantly, the contingency fund portion of the security will be retained by the department for an agreed period or until mining officers have confirmed that the rehabilitation has been deemed successful and the project area is considered safe, stable, self-sustainable and non-polluting, and no further rehabilitation and remediation works, sites, visits or whatever. So,
Or monitoring.
sorry?
Or monitoring.
Yes,
Will be
all
required.
monitoring will be required. So all of that happens before the issue of the Section 46 closure.
Yes.
But my point is that part of this security calculation includes a kind of a what if we missed something amount.
Yes, of course.
And so we say in assessing whether or not missing anything is unreasonable, if what was missed is small, Your Honour won't be satisfied that it's unreasonable, because there is this contingency. That's part of the process, is to add on a not insubstantial sum in case anything has been overlooked or underestimated.
Yes.
So we say on the basis of that, Your Honour doesn't have to immerse yourself in the detail of the security calculation. Your Honour is not an expert in security calculations. My friends are not experts. There is no expert evidence. All you know is that experts looked at it, and an expert auditor reviewed it and thought that it was reasonable. That's all the court knows. Now, we say that in assessing what is reasonable, this relates to the point that I had discussed earlier about Singh and the fact that there's no obligation to give reasons for this stuff. My friend relies upon Singh, as we understand it in this context. We say you can't draw anything from the so-called statement of reasons of the minister because it just never addressed it at this minute level. So you can't say, well, because she didn't explain why she chose 10 years for this or whatever, therefore it's unreasonable. We say that's not the right way of going about it. There's no obligation to give reasons for a security decision at all. That's not to deny that it can't be challenged for unreasonableness. We accept that certainly since Avon Downs in the High Court, it's accepted that even where there's no statement of reasons, the court can look at all of the material that was before the minister, also material that was constructively before the minister. In a case called Prasad, a decision at 6 Federal Court Reports 155, Justice Wilcox would even extend that
Sorry,
to...
could you slow down a little bit for that?
Sorry.
6 Federal Court Reports.
155, Justice Wilcox at 169. I won't...
What's the name of the case again?
Prasad, Prasad,
Oh, right.
and the Minister for Immigration.
Thanks. No, just hang on to that.
The only point of this is that unreasonableness to be established, one looks at what was before the minister, what was constructively before the minister, and also what was not before the minister, but only not before the minister because the minister unreasonably failed to get it. That is the pool of things that one can have regard to. And one can also have regard to if the issue is one involving expertise, expert evidence. And so in that respect, if I can take Your Honour to Arnold and the Minister administering the Water Management Act.
Wait a minute. Sorry.
We
Okay.
may have a copy for you, Your Honour.
Okay. So what am I looking at? Arnold?
Arnold and the Minister administering the Water Management Act 2000. I'll hand this up as well to save walking.
Thank you. That would be handy.
I'll just keep it because it's handy. So the first passage I take you to in this is paragraph 1.
I've got 2 here. What is this?
1 is the appeal.
Okay. Which am I? Oh, okay.
Starting first of all with Justice Biscoe's judgment.
Yes.
Paragraph 124. So in the second paragraph of that, in the second sentence, His Honour says, in principle and on authorities, expert evidence can be tolerated in some circumstances, including at the edge of judicial review, at the high and usually insurmountable barrier of the ground of manifest unreasonableness, if it is relevant to the proposition that, on the material before the decision maker, the decision was manifestly unreasonable.
Yes.
No violence is done to the general principle that judicial review grounds, other than jurisdictional fact, are determined by reference to the material before the decision maker, if it is acknowledged that the expert evidence may be required to show that the material was fallacious and operated to produce an absurd result. So that's possible. Now going in this decision to 193. At 193 is on starts to consider the irrationality ground. At 194 is plain that the minister relied upon certain expert material. In that case, it was a model about aquifers. The key model was found to have had deficiencies, albeit that it was thought to be in the right order of magnitude, which is to say it wasn't out by more than a factor of 10, I think.
Yes, it does.
Suggested.
That is exactly what it means.
And so that was the model that the minister accepted. Then at 199, it says the applicant submits that the minister's decision to make the plan was completely unreasonable because he knew or ought to have known that the EcoSeal model was completely unsound and unreliable. I disagree. Aquaterra, Mr. Williams and Professor Pathapar had given the EcoSeal a significant measure of support. So why I use this case is you have a model. The model was flawed. Everyone accepted it was flawed. But an expert had sort of said, yeah, it's pretty good. The ground was then dismissed on that basis. Then there was an appeal to the Court of Appeal. Same issue. That is in Arnold, 2014, New South Wales Court of Appeal 386. Okay, my computer doesn't want to.
What was the upshot?
The other case is 2014 New South Wales NSWCA 386, and the decision of the New South Wales Court of Appeal, and the relevant passage is at 118. They were considering this issue, and Justice Tobias, who gave the judgment for the court, in my view, there was constructively before the minister material of sufficient probative value as to enable him to make the plan, notwithstanding the flaws in the EcoSeal, in circumstances which were neither illogical nor irrational. To adopt the words of the plurality in Lee, the minister's decision to make the plan did not lack an evident and intelligible justification when its provisions are considered as a whole. So what we get from those cases is that in a process where there's something like an expert model, here the calculation is basically an expert model of a kind. In that case, it was an aquifer water model. The minister does the best they can, and if they've got advice and it seems reasonable and they're told that it's reasonable, then Your Honour shouldn't find that it was unreasonable, even if it's flawed. Also, if I make this clear, my friend handed up a case this morning called WCJS, which was the case about fundamental flaws in relation to factual matters of mandatory relevant considerations can go to jurisdiction. But we would say that the question of the length of post-closure monitoring is not a mandatory relevant consideration. And certainly nothing in the Act makes it such.
But the way the plaintiff puts it is that the mandatory relevant consideration is that the calculation must be based on the actual cost. Calculation must be calculated by reference to the level of disturbance likely to be caused by the mining activities.
Yes,
And
well,
that brings in those other factors which,
we say that that's a huge amount of work to go from having regard to the level of disturbance, which is actually the mine bulldozed this area,
Yes.
to how much monitoring you have. I'm not saying that that isn't something that you should have regard to. We did have regard to it. Maybe, I don't accept this, but maybe we got it wrong. But our point is that even if it's wrong,
Yes.
Your Honour should not
all right,
allow that ground. Now, I've mentioned a point about post-closure monitoring. I just want to take Your Honour to a tab to make sure that I've given Your Honour some evidence for that point, which is tab 141. I think it's in our bundle that we gave this morning. Sorry. The second of the folders. In 8.
swappy. Thank you. Yes? This is the guidelines for preparing mine closure plans
Yes.
from Western Australia.
So the bit that I wanted to take through here starts at page 4930. And it has a table which just helpfully identifies,
I'm sorry, would you mind repeating the page?
4930.
Thank you.
A table which sort of divides, not sort of, does divide the process of mining into different phases. So it starts with the exploration phase, one sees that at 4930. Then there's the planning and design phase, the construction phase, next page, operations phase, then the decommissioning phase, and then finally is the post-closure monitoring and maintenance phase. And I note that it's described as consultation continues through to relinquishment. So we say relinquishment is
When you get your certificate.
when you get your certificate. So I just use that to make clear that, because the reason why I do it is because Your Honour will read this, go away and read this in due course, and the word closure is attached to two different things in different contexts. In the context of section 46, closure means the closure of the site. At the end of the closure
At the
of
end
the
of
site,
at the end of the rehabilitation
the
phase.
mine has walked away, the lease comes to an end, it's all over. But there's another kind of closure, which is the closure of the extraction processes.
Yes.
And these post-closure monitoring are post the extraction processes, but before the closure of the
Yes,
mine.
I do understand that.
Thank you, Your Honour.
I should just, sorry, I know at the time. Are we going to take an afternoon break? Does anybody require one? Council? Okay, let's go.
Your Honour. Now, we say that a difficulty with my friend's approach is my friend asked the court to conclude that the 10 years of so-called post-closure monitoring is not long enough. But there is...
I didn't think he said, well, he did say it wasn't long enough, but that's not his major point. His major point was that it was arbitrarily chosen, when all of the material seemed to suggest that 100 to 1,000 years monitoring would be required.
Yes, well, let me address that. we say, and in same document, I think on page 4952, document. So at the end of that passage on 4952, about the second half of that last paragraph, or take the last paragraph. The measurement techniques considered in the program must be able to demonstrate that the site-specific completion criteria and environment indicators have been met. Evidence that adequate resources have been set aside to implement the program is required. This will account for the expectation that the monitoring and maintenance period will extend for many years after closure until it can be demonstrated that closure outcomes and completion criteria have been met. In the early stages of the project, I'll focus upon that, or where detailed information on closure performance is not available, a minimum monitoring period after closure should be provided for the mine closure plans in the order of 10 years. Now, that is the amount that was chosen. Your Honour will recall that I took Your Honour to the MRM's plan, which referred specifically to this guideline. So we have a guideline that says in the early stages. Well, is this the early stages? Your Honour might say, well, this mine's been going for a while. But of course, it went for a long time. It was an underground mine. And so let me make good the proposition that we are still in the early stages. And that requires going to the EIS, the report 86, which is tab 130, P2.
Hang on, sorry. Now, where am I going, sir?
To P2, exhibit P2.
Which is?
It's the report 86.
Report 86.
Report 86
Okay.
of the EPA report. The assessment report.
Thank you. Yes, and what page?
4390. Your Honour looks at the bottom of 4390.
Just let me get 4390. Yes?
This is a 2018 report, and in the last paragraph there it says, overburden has been placed at the current site since 2008 and currently contains about 25 million tonnes of waste rock. So that's current amount of stuff currently in the overburden. Now, if I go to 4402 in the same document. Your Honour will see.
4402.
Yes. What's the difference?
Yes?
Okay. Is Your Honour on 4402?
Yes. What does MT stand for? Million tonnes.
Well, I was corrected and told that it stands for megatons. I then asked what a megaton was, and I was told it was 1 million tonnes.
Okay.
So, whichever one Your Honour prefers, it seems to work.
Okay.
The relevant.
530 million tonnes or megatons.
No, the 595.
Is it?
Just
Oh, I see.
The
Yes.
proposed.
Proposed, yeah.
So the point
So you
is,
say 25 is only at the beginning of 595.
at the very beginning of this whole pit digging exercise. And so at the very beginning, 10 years worth of monitoring. Now, it may well be, we accept that when you get to 595, then by that time you'll know a lot more about the way things are working, you'll have your experts in place. They may well recommend a longer amount of monitoring before you hand back the security. But we say that your owner shouldn't be satisfied, because the onus is on them. The owner shouldn't be satisfied that following the West Australian guideline is innately unreasonable when it's reasonable to think this is an early stage of the process, and that 10 years at this point is a reasonable amount.
I see.
Now, the next thing, so that deals with the sort of the 10-year issue. The remaining issues are...
Well, but part of that point is that you're saying it's not arbitrary. It's not just an accident that it's on the form there.
Exactly. I mean, my friends might say that that's unreasonable and that in light of other things you should do longer, but they don't have an expert saying that, and we just say, absent that, Your Honour shouldn't, just because a closure objective might be 1,000 years of good land, that doesn't mean 1,000 years of monitoring. So I now want to address the second aspect of this security calculation error is there are three things said not to be included at all. The first one is the mine levy wall. We've addressed that in our submissions. We accept that that was omitted, but we say that Your Honour should still not find it unreasonable because we made inquiries of MRM, and this is all set out in our written submissions at 97 to 98. We made inquiries of MRM, and MRM told us that they had included it inside of a different figure. Now, maybe they didn't, but we say a mistake of that kind does not lead to unreasonableness. That then leaves the so-called W-prod and S-prod, which I think is the Western, what is it called? Perimeter runoff dam and the Southern perimeter runoff dam. Now, these two things we accept are not included. But now, if I can take Your Honour to the model, and let me foreshadow what I'm about to say. The non-inclusion of them is $81,000. That's what we missed. In the $400 million of security, we missed 81,000. And if I can...
So, not a big deal.
Not a big deal. Well, it's not a material amount. It's 0.01% or something, or less than that, I think, of the amount. But if I can... What we're getting up on the screen, if you want to look at the screen, the difficulty is that to make good this point,
Well, I've got a big black square in the middle of my screen and I can't see that screen. So if we shift it so that what I'm looking at is up the top there. Bill, do you want to have a look? Doesn't normally. No, I know. It doesn't go away. It sits there in the middle when I'm watching. So see down the side, you've got 12, 13, 14, 15, 16, 17. Yes. If you tell me what row I'm looking at. Oh, it did go away.
We're looking at row 13.
13, okay.
So, you know, I was looking at row 13. It's called earthwork maintenance. You want to see that?
Vaguely.
So, in column C and D, it says earthwork maintenance at row 13.
Yes, I've got that.
Okay, so, and that's where S prod and W prod should be, but are missing. To show that they're missing, if we click on page 13.
Hang on. Should be in 13. Is it earthworks maintenance? Is that what it's at? Earthwork maintenance, yeah? Missing, yes?
Now, my construction solicitor has just clicked on the box, which is H13. The virus says
Yes.
slightly green around that. When you click on that box, and that's why we can't give you a piece of paper with this.
H13 says 325.36.
Exactly, but at the top, you want to see is the top, there's a box above the letters at the top, it starts off saying equals key information B9, B10, B11. Do you want to see that?
I can. Don't make any sense of it, but I can see it.
Okay, so what we're listed there is that this 325 hectares is made up by all of these things that are B9 up to B17.
Can I just, before we go through all this, Mr. Jones, do you accept that the actual figure for the W prod and S prod could be demonstrated by this process to be minimal?
No.
Right, thank you. Keep going, Mr. Lloyd.
Okay, so, I go to the screen and show you what the things are. So, the those three things add to this screen. So, down the column, down the left here, you'll see various forms of disturbance between beings, and B9 is waste rock dump, 1, 2, 3, 4, 5, tailings dam, 1, 2, 3, 4. Do you want to see that?
Yeah.
So that, they are the things, and the areas in red that are included, are extended. But if you want to see 23, B27, the water ponds, dams, 185. See that? Yeah. So that one was not included in the previous thing. That's where we say the W product S product is. And so we'll go to the
Can I just make a helpful suggestion, because I'm not going to follow this. I've already forgotten what the first part was that you told me. Can I make a suggestion that you demonstrate in writing after the fact that the cost of the maintenance costs of W prod and S prod that are not included are, you say $81,000, but in other words, but minimal, and then Mr. Jones can have an opportunity to respond in writing to that, because otherwise this is just going to take all afternoon and I won't follow anyway.
I'm entirely content with that. We'll just include a document and we'll include screenshots as to.
Yes, that would be helpful, and a little explanation of those.
Anyway, so our point here is that
Confess and avoid. They're not there, but they're not
they're
material.
minimal, and ultimately the onus is on the applicants to show that,
Yes.
that the missing of them is unreasonable.
That gives
and
rise to unreasonableness.
So that they should have led some evidence to show it. So even if this all falls over, we'd say we still win because they haven't shown that missing it is a significant omission in any event.
Yes.
I think that's all I need to do in the second issue. And now move on to the third issue, section, whether the closure plan, the UCP, meets the criteria of section 42G. In many respects, I've addressed this when I was going through the Act. The plaintiffs say that it doesn't. We say that the unplanned closure plan doesn't replace the conceptual mine closure plan, although the conceptual mine closure plan has itself, in effect, been rejected
because it had, even at the end of the mine, the covering up of the tailings rather than putting them in the pit.
the conceptual mine closure plan has them in the pit.
That's what I said. Oh,
The conceptual mine closure, the unplanned closure plan, which is just for the short term, has them.
I thought that the conceptual mine, so why was the conceptual mining was conceptual closure plan rejected? It was something about, or was it the overburden? Can't remember. Tell
So,
me.
I'll tell you. So the conceptual mine closure plan was accepted by the EPA, but it involves, sorry? Oh, no, I take that back.
It was rejected,
But, well,
wasn't it? And it had something to do with,
oh
The
yes,
tailings
so
not
I
going
think,
into
I
the
think
pit?
that's true. The EPA didn't accept the conceptual mine closure plan because they thought there were too many uncertainties and you would need to get this panel of experts in, and that's why they recommended getting, an independent panel to advise on a mine closure plan. But it also had a problem, a separate problem, which was it envisaged that the lake would be hydraulically linked to
That's
the
it.
river.
That's it.
But the EPBC Act approval, which came later, said, well, subject to getting a separate approval, you can't link it to the river. So, there was a conceptual mine
Commonwealth
closure
had
plan,
rejected that, yes.
but it isn't viable for a number of reasons. But we still have a mine that has, like, even if the mine stopped mining, we still have tailings on site. And so there needs to be a plan of what to do if MRM just say we don't want to mine anymore. The pit isn't, we say, deep enough to put the tailings in the pit. And so there is, in fact, an unplanned closure plan, which is the plan which says, what is the best thing to do to close the mine in the circumstances that we are currently in, having regard to the currently approved or authorised activities, although I realise that's somewhat controversial, that expression. Let me say that the activities that can be carried out under the authorisation, consistent with the conditions. So we say that is what is required under the Act. You need to have a plan to do something like that. The unplanned closure plan does do that. I think in their written submissions, in their reply, they say the unplanned closure plan doesn't contain details of rehabilitation activities. We say it does, and I'll give you a reference to that. It's in tab 57, page 2238 and following. Talks about rehabilitation landform designs. So that is addressed at least to some extent.
What was that page number again?
Sorry? That's exhibit P7, and the pages are 2238 and following. And then, I'm not sure exactly where this goes, but the submissions in there, the plaintiffs in their written submissions, and I think also orally yesterday, made a submission that it's doubtful in an unplanned closure scenario that the operator would seek a certificate of closure under section 46. We don't know why that is doubtful. MRM,
If there is an unplanned closure and they've put the money up and they want their money back, then they're going to want a certificate.
exactly. They have,
They will get a certificate if they have complied with the plan that's approved.
to the satisfaction of the minister, or possibly.
Well, not, actually, there's an objective test, isn't there?
And exactly. So
Because
the satisfaction of the minister, or failing that, if they can prove it. I think that's all I need to say about ground 3. And ground 4 is now the EPA consistency ground. I have already kind of foreshadowed where I'm going with this material as well.
yes, I'm pretty sure I understand your submissions in relation to that because you made them fairly clear when you were going through
Yeah,
the
so if
material.
I can just recap it
Yes, of course.
briefly. We say we accept that the minister was bound to have regard to the EPA, and there's no dispute that she did have regard to it. We accept that if the authorisation was inconsistent with the EPA recommendations, she should have notified Parliament. She didn't think it was inconsistent, and she didn't notify Parliament. But even if she was wrong about it being not inconsistent, the only relief that could be sought from somebody who had standing would be to compel her to notify Parliament, because that would be what she failed to do. That isn't sought by the plaintiffs quite properly, and they wouldn't have standing, we would say, for that in any event. So we say we've already taken the court to show that the minister knew about the issue about what might have been thought to be an inconsistency about not putting the tailings into the pit in the very early stages.
And had reasoned her way to a conclusion that there was no inconsistency.
Exactly.
Because the pit wouldn't have been deep enough, and the overall overarching objective in the EPA was to keep the river safe. Is that right? Can I just make a note of that though? So the minister knew about the suggested inconsistency. Is that the way you put it?
Or the conceivable inconsistency.
Conceivable. And, on advice, had reasoned to the conclusion that there was no inconsistency because pit not deep enough yet to do what was.
Yes.
And the suggested solution was consistent with the overarching objective of the EPA.
That's so. I should perhaps say, there's other things I could say about the table showing that there's a bona fide attempt to have a recommendation. Every recommendation, there's a table somewhere I could take you on to, which shows that for every recommendation in the EPA report, there's a condition in the authorisation that seeks to give effect to it, but I don't understand that that's really an issue, so I won't do that. My friend put forward a letter this morning from March 2022 from the EPA, and he had yesterday put forward a letter more recent than that. I can't remember the date of it, but maybe August or something, 2022, from the EPA, whereby one letter, well, I'll let Your Honour read the letters and extract what you think you can extract from them. But what we would say, what Your Honour should extract from them is that they're both post the Minister's decision. And so the EPA now seems to say that it thinks that the plan is inconsistent with the recommendations. Our answer to that was, well, we spoke to their representatives and got a no further action at the time. That's how things were at the time the Minister made a decision.
But in any event, it's not the EPA's opinion that counts.
No, exactly. We embrace that as well. But I'm not sure exactly where my friend will go with those documents, but we say that they're of no significance. And then I think there may be some controversy, I don't know what's going to come up in reply, but some controversy about whether or not those Department of Environment people do represent the EPA. We say...
Does it matter? The question is whether the Minister's conduct is unreasonable.
I agree, and we would say, Well, Mr. Padovan, who has worked in the area for 6 years, he thought he was meeting with people who represented the EPA and discussed it with them and thought that they were okay with it. That was enough to inform the process and make it reasonable. But to the extent that my friends say that isn't...
If you met the wrong people,
met the wrong people or something, exactly how that meeting went down, if they were the wrong people, why they sat there and listened about this mine, it's unclear. But I would also just draw your honour's attention to, in the casebook, there's a document, tab 113, which I think is in our...
it's Exhibit D5.
D5. Sorry. No, this one is the email. Anyway, it's in D5. The bit that I wanted to draw your honour's attention to is that
Do you have that?
I have...
No, but we're getting it. Hang on, I might have it. 113, you say?
Might be P20.
Yep, I think it's, I've got it. I think. Oh no, 107. No, what's that? 113, yes.
113. The point here is this attaches a letter friends rely upon. But what we want to draw attention to is just that it's sent from Alison Waters. Does you want to see that? Not the letter, the email.
On the email, all right. Yes?
So she's an executive officer, the Department of the Environment, providing services for the NTEPA. And so this idea that these people actually were representing the NTEPA is not somehow a fantasy of Mr. Padovan, but likely to be correct, and certainly hasn't been established not to be correct. So if it's an issue, maybe it isn't. We don't need it, but in any event, we say there was communications with people who basically act for the EPA.
Act 4 is different from providing services to, doesn't it really? I mean, you say you've got the Law Reform Commission, and then you've got the executive officer from the department who provides secretarial services. Wouldn't necessarily talk to the person who's providing the services if you wanted to talk to the Law Reform Commission, would you? You'd be talking to the commissioners or the chairman or whatever.
Well, we would say that in the first instance, when you've got bureaucrats on one side and bureaucrats on the other side, the bureaucrats who are servicing the statutory appointees are the people you touch base with.
Yes.
And that's all we're saying. We had a meeting with the people who are the people working for the statutory appointees and got clearance from them. So it was at least viable for the minister in the circumstances of all that happening to think that the proposal was consistent with the recommendations, or to reasonably think that. So that's all I want to say about ground 4. In our written submissions, we had a section which we now, in effect, recant from. I think we accept that if Your Honour finds that the security decision as posited is invalid in the sense of there's a jurisdictional error in the making of it.
Hang on, security decision invalid for jurisdictional error, yes. Then what?
Then we don't say, and we're withdrawing our submissions that I think did say this, we don't say that the authorisation decision is not also invalid. Or putting it more positively, if the security decision is invalid, that would invalidate the authorisation decision.
Okay.
Yeah, I mean, obviously we say the security decision isn't invalid,
Yes,
but if it were invalid, and that seems to flow inexorably from how we say the authorisation works.
Yes.
That if there's no valid security decision, then no mining activities have been authorised at all. So that then brings me to the last issue, which is the discretionary refusal of relief issue. I've kind of foreshadowed that already. Our point is the current security is a security set under the 2022 variation, which I've set into. And the way the variations work is there's the original authorisation and the conditions that were in that are substituted out and a new one is put in each time. So
so the one being challenged is...
not the current one. And so...
well, so what do you say flows? It's supposing that plaintiffs are right and this process is flawed. Shouldn't be done that way. It has to be, you know, the way that Justice Southwood explained in Territory, whatever it is, Territory, what's the name of the case?
So
Supposing that proposition is right, then it would follow that although the 2020 decision, which is under attack, is not the operative decision, you've got two further decisions which are infected with the same fatal flaw. So what do you say would be the appropriate remedy for the plaintiff in those circumstances?
we say that you could give a declaration saying that that context, the security decision made in 2020 was contrary to the requirements of section, I don't know, whatever it is, 43A or an implication from 43A, because it didn't cover all of the possible mining activities that would occur under the life of the mine. And just leave that as a declaration. There would be no other quashing of anything.
Yes.
Now, my client, being, you know, the executive of the Northern Territory government, will no doubt take on board what that means for any other securities subsequently done.
Yes.
So
Without
I'm not saying there won't be
upsetting the apple
consequences
cart on
done.
what's happened before.
Exactly. That they may have a bit of time to do whatever it is they want to do, to make a new decision. I mean, it's hard to see exactly how a new decision will be made in those circumstances, given that the EPA said you can only work out what should be done by getting experts in and testing things over a period of time. So if you're on a find that you have to do everything at the beginning and it can't all be done at the beginning, then short of the Act changing, it's hard to see how anything can proceed. But we obviously say that's wrong.
Yes, you do.
But if that's the position, then my client from the declaration will know that and they will have to take action accordingly. But not pursuant to a court order, but just through the normal administration of what happens.
Well, that's exactly right. They would then set whatever the security is to be by reference to what is the anticipated cost of clearing up whatever's going to happen at the end of the life of the mine.
I'm instructed that the 2023 decision is being made now, so maybe it probably will be made before Your Honour reaches a judgment, but I mean, if it isn't, then...
I'm going to do it as quickly as I can, but...
we appreciate that, Your Honour. Then we'll take that on board, and if it's fixable in the short term, no doubt they'll try and fix it. If not, that will be something for the legislature or someone who isn't me to
That's right.
address. May it please the court?
Yes, thank you very much, Mr. Lloyd. Mr. Jones, reply.
Yes, Your Honour. If I could address the issues in the order in which I addressed them in my opening submissions. There is some taxonomical confusion that Mr. Lloyd and I have created. I labelled mine issues, issue 1, issue 2 and issue 3. Mr. Lloyd has 4 and they're in a different order, but I know Your Honour
I can
knows
figure
what
it
the
out.
issues are. The first issue is the closure plan, and the question of whether the closure plan needs to be a plan for closure after the activities that are intended at the mine conclude. Now, despite the other differences between the parties, which I'll come to in a moment, there can be no doubt that the Minister approved the mining management plan.
Yes.
The mining management plan, as Your Honour knows, contemplates extraction until 2037 and, well, that's it at present because it doesn't contain a closure plan for that period. Now, without a closure plan as to what is to occur after 2037, by reference to the footprint of the mine as it exists in 2037, and of course it's going to be much bigger, the pit will be much bigger in 2037 than it is today. Without that plan, there can be no long-term planning for that eventuality. There can be no foresight exercised as to what will take place progressively to reach that point. And there cannot be, and has not been, any oversight by the Minister or her department as to the content of that plan and whether it is adequate. All that exists, and we are told will continue to exist until perhaps 2032, is a series of year-by-year unplanned closure plans, which by definition contemplate a precipitous and unplanned and unintended closure at the end of that relevant year, so within 12 months of the plan actually being created. Now, it necessarily follows that what that means is that the planning is always short-term. Now, the conceptual mine closure plan, as Your Honour knows, has been rejected because of its desire for hydraulic linkage. But at least the conceptual mine closure plan endeavoured to do those things which I've just highlighted for Your Honour. And it really is common sense in my submission that the legislature would have intended that the requirement under section 42G meant that the plan had to be a plan for what was intended to happen at the mine at the conclusion of the intended and approved activities. An unplanned closure plan, despite the nomenclature, is really, in many ways, not a plan at all, in the sense that it is not planned to happen. Now, it may be necessary, as I submitted to Your Honour yesterday, but it is certainly not sufficient. Now, the fulcrum of my learned friend's submissions in relation to this issue was that it was sufficient that there be a plan to rehabilitate activities, he said, currently to be carried out under the authorisation. And he said in this afternoon, consistently with the conditions. Now, first of all, that links his argument about to be carried out to the second issue about security, and I'll come on to that in a moment and say that that's wrong. But the linkage itself is inappropriate because the words to be carried out are used in section 43A, but they have no place, they are not used in section 40 subsection 2G. So to attempt to limit the requirement in section 40 subsection 2G.
In 43A, not 42G.
Yes, Your Honour. And to attempt to limit it by that phrase in order to cast validity upon the use of the unplanned closure plan is reading words into that section that are simply not there.
You just say it's not a legitimate construction exercise to read
No.
words into section 42G, but do you really have to read words into 42G?
Your Honour does, no, Your Honour, is the short answer to that question. To achieve what my learned friend says, you certainly have to construe it in a very narrow way.
Why? You see, the thing is, you're saying that it needs to be construed in one way and one way only, i.e. a plan and costing of closure activities at the end of the proposed mining activities at the end of the life of the mine. Arguably a narrower reading than Mr. Lloyd, who's said that it could be a plan for closure activities at the end of the life of the mine, but it also could be it is wide enough, he says, to encompass the cost of closure activities at the end of the current, assuming if the mine were to close at the end of the the work that is to be performed, or whatever those words are.
Yes, well, what my learned friend said, I think at one point was
under the authorisation for the current period.
Yes, quite, Your Honour. My learned friend said what it requires is a plan for what happens at the end of the authorised mining activities.
I think he then withdrew that and said that it was at the end of the mining activities to be carried out under the authorisation.
Those words just aren't in 42G, Your Honour. That's why I said that's a fulcrum of the submission. And the withdrawal of to be a plan at the end of authorised mining activities, I must have been distracted and didn't hear the withdrawal, but it's consistent with the fact that it's quite obvious in my submission that the mining management plan had been approved and authorised. And so the plan that is contemplated is what will happen at the end of what everyone hopes and intends will occur.
Look, I really do understand the different positions. You say that, you have to look at what's been authorised, and clearly under that mining management plan, the whole lot has been authorised, and therefore it has to be the cost of, making good, if you like, those activities.
Your Honour has
all of them. And Mr. Lloyd is saying, well, no, it can be by reference to that particular plan. There's only a very limited number of activities that can be carried out under that authorisation.
I'll come to that in a moment.
They're two.
Yes, Your Honour has the point of cogitate.
I have the point.
I'm sure. Can I just pick up a couple of more points that go to this issue? There was discussion about the closure criteria in section 46 and the return of the security.
Yes.
And it was said, well, that can apply in a case of unplanned closure. And I think the submission went slightly further to say, well, that must be what's applying in the case of unplanned closure, because that's how you get your money back.
Yes.
That overlooks section 43A, subsection 3.
Okay, hang on. And closure plan. You say that overlooks
43 capital A, subsection 3.
Why? How?
That provides that any part of the security not required for the purpose mentioned in 43.2 is refundable.
Yes.
And it is that provision in my submission that my learned friend took you to the security procedure guide that talked about the staged return of the security. Now, there's nothing in section 46 about the staged return of the security.
No, that happens at the end. After the operator has fulfilled all the
Section 46
criteria
does, yes, Your Honour. Yes,
in the
quite.
closure
Quite.
plan, whatever the closure plan may be.
Quite, yes, Your Honour. So that's success. Section 46 is dealing with
Yes.
success. And Section 43A3 is dealing with a wider issue that enables the minister or requires the minister to refund anything that the minister determines is not required for the purposes of Section 43.2.
So, for example, when they found a cheaper method of dealing with their overburden, and they
Yes.
got their $119 million back.
Yes, well, a purportedly cheaper version, Your Honour. I should say we don't accept what my learned friend said about the
No, but that's an
compacted clay
example,
liner
assuming
or the
that that's-
geosynthetic liner. But yes, that's an example. And another example would be, in terms of getting the money back at the end of 1,000 years, one might be able to get, the operator might be able to get a lot of the money back prior to that time, but it's just the money that is required for the remaining monitoring.
Does he
and
get
maintenance
interest
operation
over that 1,000 years?
is quarantined. I don't know the terms on which the security is held, Your Honour. With rising
Add up
interest
to a
rates,
bit,
perhaps they would like the 1,000 years. So, Your Honour, the simple point I make is that not all unplanned closures will occur under the process in Section 46. One would expect, by the nature of an unplanned closure, many of them unplanned, unexpected, unintended, will be something going wrong in the mining operator's plans, such that the minister needs to step in or some emergency measures need to happen.
You never know.
Well, you never know, Your Honour, but I would say it's quite likely in the case of an unplanned closure plan that that's going to be
Yes.
the case. So it remains the case that Section 46 is focused on successful closure, and I do continue to rely on that to say, well, successful closure really does suggest that one is in a world where everything has gone to plan.
Maybe.
It should at least include that, Your Honour, and on my learned friend's
Well, it
construction,
would include
Section
it, wouldn't
42G,
it?
it doesn't need to include it.
Well, what Mr Lloyd is saying is, well, look, if you've got a plan that says, you know, we're going to do these things to rehabilitate the area, after the mine has, you know, successfully run its course and we've taken everything out we want to, you know, take out, and that's 2037 or what have you in this case, then you tick off all the boxes in that plan, and once it's successfully completed, you get your money back. Whereas if you have an unplanned closure plan and, contrary to expectations, the mine has to close unexpectedly, then you have a look at your unplanned closure plan, you tick off all the boxes, it says what you're going to do in those circumstances, and once you've done them all, you get your money back. Section 46 would operate the same in both cases.
As long as the operator is doing it. Yes, Your Honour. As
Yes.
long as the operator is doing
So long
it.
as the operator is doing it, yes.
Yes. My submission is simply, it's not an answer to our reliance on the reference to successful closure to say that a successful closure by reference to the closure criteria could occur in an unplanned closure scenario. It's still the case that what is being contemplated by the Act is compliance with what everyone intends and hopes to happen. That's my submission.
Yes, all right, thank you.
Now, if I could just say something about whether the condition 96, Your Honour will remember, is the condition that requires the submission of a mining closure plan with, let me just say, a future MMP. I'll come to how one reads that
So
condition.
this is a 5-year before the end of the...
Yes, that's condition 98. But condition 96 is the one that says when there's a future MMP, you need to submit a mine closure plan.
Yes,
Now, as I've said to Your Honour before, that in my submission is really a recognition of the necessity of a mine closure plan and supports my construction of Section 42G, because everyone seems to recognise that this thing is necessary. The question is, can one kick the can down the road in the way that is done in conditions 96, 97 and 98? Now, my learned friend also submitted that with these amended unplanned closure plans that have been submitted, that those were, and I think this submission is correct, those were amendments to the mining management plan, because the unplanned closure plan is an appendix to the mining management plan.
Yes,
Now, if that is correct, Your Honour, then we would say that condition 96 has been triggered, and one would expect to see the mine closure plan produced.
yes, but that's on the assumption that the mine closure plan in section 96 refers to a mine closure plan at the end of the proposed activities.
Oh, but
in the mine.
that's precisely what's being referred to in 96, Your Honour. I don't
But
think
it's-
there's any.
what
96 is in volume 5, tab 61.
Okay, volume 5, tab 61, could I have that, please? Or have I got it already? Got it, I think. Yes, hang on, got it.
Yes, Your Honour, it's at the back, 2386.
Yeah.
386.
From the date of authorisation of the overburden management project, the operator must submit an updated
Yes.
mine closure plan with each MMP that builds upon closure concepts defined in the overburden management
Yes.
project.
So it's referring to an updated mine closure plan from the conceptual mine closure plan.
Why do you say that?
Well, Your Honour will see mine closure
Yes,
distinguished from unplanned mine closure, so between 96 and 99. So 99
where's
is
the
referring,
unplanned?
99 is referring to the unplanned mine closure plan,
I see.
and then 96 is referring to the mine closure plan. And what this is,
It might just be referring to any mine closure, planned or unplanned, mightn't it be?
well, I don't think so, Your Honour, because it refers to building upon the closure concepts defined in the overburden management project. And the
Yes.
closure concepts defined in the overburden management project, Your Honour will remember that was the one submitted in the EIS. Those closure concepts are contained in the conceptual mine closure plan. So it's not just any plan. What is being said here is we appreciate we need this plan. One is not ready at the moment, so we need to prepare one in the future, or one will need to be prepared in the future. Now, Your Honour, there's an issue of how one reads 96 that I'll just flag for Your Honour, and Your Honour will no doubt have your own view about it. The words at the end of 96, that builds upon the closure concepts defined in the overburden management project. A learned friend says that those words attach to or qualify MMP, as I understand his submission. So he's saying you only need to produce a mine closure plan if you've got an MMP that builds upon.
That's the way I would have read it. How would you read it?
With respect, the correct reading, Your Honour, is the operator must submit an updated mine closure plan, that's the noun, with each MMP that builds. So it's the updated mine closure plan that builds.
Okay,
That's, in my submission, clearly the correct construction, because it was the conceptual mine closure plan in the EIS that was the thing that contained the closure objectives. And it's that thing that is being updated.
yes, thank you for that.
So the only point I make in relation to that, Your Honour, is, if I could just sort of crystallise it, those conditions show mine closure plan necessary, and I say that's
You mean
my
final mine closure plan?
I mean final mine closure plan, which is referred to in condition 96 as mine closure plan. And I also say on my learned friend's approach to these updated unplanned closure plans, condition 96 has now been triggered.
See, one way of just looking at that, if you would be to say, look, you are reading the word final into mine closure plan. It could be any mine closure plan, planned or unplanned. And all that 96 does is to say, look, okay, you have to put in a new mine closure plan, unplanned one, every 12 months. But in addition to the one that you have to put in every 12 months, if you make an amendment to your mine management plan that builds on the closure concepts defined in the overburden management project, then you have to put in an additional amended mine management plan.
No, with respect, Your Honour, that's the wrong reading. If one looks at condition 98, 5 years prior to the planned closure of the mine, the operator must finalise the mine closure plan.
Required under 96.
Required under condition 96, so it's clearly linking
Yes, okay.
to the end. And so on my learned friends approach, there's been a breach of condition 96, which on my learned friends approach also means that MRM is conducting unlawful mining activities.
No, don't say that.
Well, I'll test that in a moment. So that's what I say about issue 1, which is the closure plan.
Yes, I understand that point. Those words in clause 98 give meaning to clause 96
Yes, Your Honour.
and show that it's meant to refer to a final mine closure plan.
Yes, Your Honour, yes. Now, the security calculation, the section 43A issue, as Your Honour knows, it's been cast at various times as saying security for the life of the mine, but really it's just a question of whether this particular calculation complies with section 43A.
Yes.
So my learned friend is right, so there's no magic in the words life of the mine. And as Your Honour knows, the inquiry here is as to what activities are likely to be caused by the mining activities to be carried out under the authorisation. Now, as Your Honour's correctly identified, there's two parts to that. First, what was authorised, and then what is to be carried out under the authorisation. Now, if I could just address those separately and in turn. The documents demonstrate that there was absolutely no condition. Let me start again. The documents evidence that the authorisation was given in relation to all of the activities in the mining management plan. There's not even a sniff anywhere in any of the contemporaneous documentation of the suggestion that's made now that the authorisation was limited by reference to the 2020 activities set out in the unplanned closure plan.
Nothing contemporaneous, you say?
That's right, Your Honour, and quite the contrary. My learned friend took you to that map of the expansion of the open pit. Do Your Honour remember? It had stage M on it, page 240, volume 2, tab 19. And the yellow stage M that was marked as seeking approval for the yellow part. And when the mining management plan was approved, that approval was being granted.
So approval sought and granted for the yellow bits.
Approval sought and granted. Now, this issue really turns on my learned friend's submission that the operator, MRM, was not authorised to carry out any activities at this site other than those.
For which security had been given.
Well, but there's a prior stage, Your Honour, other than those that are the 20 activities in the mining management plan for which security had been given.
Yes, that's
Now,
that.
Yes, in the UCP attached to the MMP. Now, I think Your Honour's identified that question really turns on the proper construction of the authorisation. Now, there's nothing in the authorisation in my submission that supports that construction, or well, it doesn't support that construction. The two conditions that are relied upon by my letter friend. First, condition 99. Every year, updated unplanned closure plan.
Yes.
And the next piece of that puzzle, and I might ask Your Honour to go to it, condition 12. This is the authorisation document, which I think Your Honour has open, page 2362.
Yes.
So the unplanned closure plan gets submitted under 99 on time. Then one comes to 11. The security provided for under condition 10 will be reassessed and may be revised
Yes.
following the submission assessment and approval of A, B and C, the unplanned closure plan.
Yes.
Now that contemplates a scenario, Your Honour, where an unplanned closure plan is submitted in accordance with condition 99, but the security, either that unplanned closure plan is not approved,
Yes.
or it's approved and the security is not revised, because there's no obligation on the department or the minister to approve it or to revise the security. Now, assume that that happens, Your Honour. MRM is in full compliance with the conditions. It's submitted its plan. There's nothing in the conditions that say it has to be approved. There's nothing in the conditions that say the security has to be revised. So MRM is in full compliance with the conditions.
Yes.
And it can then continue to carry out the other activities in the mining management plan. There's no limit on it doing so. And in relation to this question, it is useful to stand back and just ask as a matter of common sense, what are the activities to be carried out under the authorisation? And what do people intend to carry out under the authorisation? All of the mining management plan activities. Now, they intend to comply with the UCP condition 99. They intend to comply with the other requirements imposed upon them by the department. And they intend to carry out all of the activities under the MMP. So those are the activities to be carried out under the authorisation. And those are the activities that need to be the subject matter for the security calculation. Now, Your Honour raised with me yesterday this question about if you breach a condition, what happens? Does that mean you're not authorised to mine anymore? And this was the point I was referring to in condition 96, and may have misunderstood my letter friend's submission, but it cannot be right that a breach of a condition means that you're not authorised to mine. What it means is you're in breach of the condition. And
That can trigger certain...
yes, and can I show, Your Honour, that under the Act?
So breach, it cannot be right that any breach of condition means you're not authorised to mine.
That's right, Your Honour, because in that world, if the operator was obliged to submit its mining management plan and it didn't do so, it would then be its mine closure plan.
Or so it did it a day late. And
Did it a day late, it's now committing unlawful operations. Now, if Your Honour has the Act,
Yes.
section 35, subsection 1, the operator for a mining site may carry out mining activities on the site only if he's granted an authorisation. If Your Honour goes forward to subsection 4 on the next page, which creates the offence, And Your Honour will see that the offence of carrying out mining activity without an authorisation is subject to a penalty of 5,000 penalty units. If Your Honour then goes forward to section 39, contravention of authorisation, and the penalty here is 250 penalty units.
Yeah.
So the penalty is 20 times higher for operating without an authorisation than it is for breaching your authorisation.
Yes.
And so what this demonstrates is that not complying with a condition, even if that's what you were doing, is radically different from carrying out unauthorised mining activity.
Yes, I get it.
My learned friend relied on paragraph 83 of Justice Southwood's decision in Territory Iron. I won't go back to it, Your Honour, but when one reads that paragraph, it's apparent that what that is about are amendments to the mining management plan that then require an amendment of the security.
Yes.
It's no support for the idea, which is pressed upon you in this case, that it's open to the Minister to only request security for part of the activities in the mining management plan. And, Your Honour, a number of submissions were made to you that it was in the operator's financial interest to do things which best protected the environment. Your Honour, if only that were true, it is in the operator's interest to do what is financially most beneficial to it. Now, on occasion, that will align with what is best for the environment, and on occasion, it will not. And if I could just give an example of how that works in this scenario. It may be the case that in 2031, the operator determines that it is no longer in its financial interests to continue with the mine. Now, at that stage, all that is left is an unplanned closure plan that's been submitted for that year. There's an unplanned closure plan, that's better than nothing. But what hasn't occurred, sorry, Honour, in the 10 years from now until that date, is proper closure planning and progressive closure planning and planning with foresight and a long-term view for going up to that point. Now,
That's arguably not the case, is it? Because if the unplanned closure plan actually does capture the cost of rehabilitating the area, assuming an unplanned closure at the end of that day, then what you've said is not correct.
well, it may capture the cost, Your Honour, but there is a difference in my submission between capturing the cost and doing the thing that results in the best environmental outcome. So
It's a bit nitpicking, isn't it? Because the whole idea is that the security is supposed to capture the cost of proper rehabilitation.
Yes, correct, Your Honour.
Assuming a closure at the end of that year. So the picture you get from what the department's practice is that, you know, because the mine gets bigger and bigger, and it's probably going to be a lot more expensive to rehabilitate, the bigger the mine gets, is that if you assume a closure now, then what you've got is security that should be sufficient to properly rehabilitate that area if it's closed and then you'll probably need a bit more to properly rehabilitate the area after more mining has been done, so that you are gradually increasing the security, and that at each stage, if it's properly calculated, you should have sufficient security to properly rehabilitate the area, assuming a closure of the mine as it then exists.
And I understand the point of that, Your Honour, of course, in terms of the costs that are involved. But in my submission, one does have to look, as a critical part of this, and this feeds into my first issue about closure planning, about what is best practice and what should be required of mining operators in terms of looking forward and progressively rehabilitating the mine. Now, the only point I was going to make in connection with that submission is to say it actually makes sense to incentivise an operator to put into effect that long-term plan, that the long-term plan exists under Section 42G at the end of the proposed mining activities,
Yes.
and that the security has to be provided up front so that it is there in the bank account.
And then
ready
if
to
you
go.
do your rehabilitation as you go along, you
And you get it
progressively
back.
get your money back
That's
instead of progressively paying out more.
That's right. It's reverse instalments in that sense, Your Honour. Yes, and we say that's clearly what the Act requires. Your Honour, I see the time. I don't think I'll take a great deal longer if Your Honour.
Yes, have we got 5 minutes? Do you think you'll take more than 5
I
minutes?
think I probably will take more than 5. I think I'll do it in 15, Your Honour. Is that acceptable to Your Honour? Might it start a bidding
You-
war?
Keep going and see how we go.
Yes, Your Honour.
We're not going to come back, so,
I understand, Your Honour. I understand.
and we're not going to sit any longer than 15 minutes.
Yes, Your Honour. The 10-year issue.
Yes,
Can I identify first an issue of law in relation to how one addresses this?
yes,
My learned friend says as a general proposition, unless there is a obligation to give reasons, a statutory obligation to give reasons, one can't assume that any reasons that are given are comprehensive.
yes,
He sought to make that proposition good by HU, the federal,
Yes.
full federal court case. Your Honour will read that and discover that it doesn't make that proposition good. It was simply holding on the facts of that particular case.
not assume reasons are comprehensive. Who is not a, you just say who is not a authority for that.
No. The real authority here, Your Honour, is the decision of the full court in Singh.
All right, well, I can read both and make
Yes.
up my mind.
I should
can't
just say though, Your Honour, my learned friend told you incorrectly that Singh was a case about a statutory obligation to give reasons by reason of its migration context. But it was in fact an adjournment decision.
So, no obligation, no statutory obligation.
No statutory obligation to give reasons. And Your Honour will see what's said there by their honours, and it plainly encompasses the facts of this case.
Okay,
Without going back to the statement of reasons, Your Honour, when one actually looks at how the headings are arranged, that last page with decision at the top actually fits with the other parts of the statement of reasons. I won't go back to it.
yes,
My learned friend relied on what he described as the expert views on the 10-year question of the department, the operator and the third-party consultant.
yes,
There's no view there. They've just adopted the 10-year figure. In relation to the reliance on the department and the operator, that's really bootstraps reasoning in my submission to say that the 10 years is legitimate, particularly in circumstances where...
just not following that. Can you just say that quickly again?
Yes, I think I'll take the colloquialism out of it, Your Honour. It's the department's decision we're challenging. They've used a 10-year figure. One can't seek to justify that by saying, well, because they've used it, it must be right, or it must be reasonable, or it must have a reason.
Yes,
And I would say really the same is true of the department, of the operator, yes.
yes, yes.
Reliance was placed on the independent expert having said the calculations were reasonable. I'll
Yes.
just give Your Honour the reference to what the independent expert actually did. Volume 2...
Wait a minute, sorry.
I'm sorry.
Reasonable. Okay, independent expert. What do you say about the independent expert?
They didn't opine on the reasonableness of the end dates.
Okay, show me. What were you going to take me to?
Yes, I don't think we've got this document in hard copy, I'm sorry, Your Honour.
Give me a reference to it and I'll find it.
Volume 2, tab 24. Oh, it's in the defendant's bundles.
Tab 24.
Should be volume 2, tab 24.
Oh, thank you. Yes, what page?
Page 438.
Yes.
And if you're on a looks at the bottom, there's bullet points at the end and then 3 paragraphs above that. That explains what the expert was doing, and it's not opining on things like the end dates, particularly when one of their jobs.
Am I looking for?
So
Subsequently,
it should
MRM.
say, yes, subsequently, and then the next paragraph down, an audit of MRM security calculation has been undertaken.
Oh, are they just opining to the reasonableness of the figures within that UCP?
Yes.
Okay.
And so you'll remember the UCP said it assumed
Yes.
10 years. So they're just saying, yes, it does assume 10 years. So that doesn't help my learned friend. The WA guidelines that Your Honour was taken to,
Yes.
the suggestion that this somehow makes the 10 years not non-arbitrary has no basis.
No.
It's, first of all, the guidelines referred to a minimum period of 10 years of monitoring. It's not endorsing a period of 10 years. It says you have to have at
Yes.
least 10 years as a general matter. And then my learned friend needs to convince Your Honour that a mine that converted to open cut in 2007 was still in its early stages by 2020. And there's just no basis for that, Your Honour. There was suggestion that this was a small error. Your Honour will have to judge that. We say it's not. We say it's a huge error. A suggestion was also made that it was just an error by the underlying departmental people.
Yes.
Now, if I could just give Your Honour a copy of a case that was in our authorities bundle. It's phosphate resources.
Yes.
And show Your Honour paragraph 95.
Sorry, 95.
95.
Yes.
This 94 and 95 address how one deals with a situation where a minister relies on work of her departmental people in this way. And the relevant sentence for my, 2 sentences for my purposes are the last 2 of paragraph 95.
Got it.
So she has relied on advice that is materially inadequate or misleading.
Such a filing may introduce legal error into the minister's decision. Whether it does so will depend upon the significance of the error or omission in the advice tendered.
Your Honour has my
Makes
position on that
perfect common
significance.
sense.
Your Honour, it's wrong to say that expert evidence is required. Expert evidence is certainly possible.
Yes.
But we don't need it, and my learned friend really made no attempt to show Your Honour that those many references in the documents to monitoring over a very lengthy period didn't contemplate exactly what they said. The mine levy wall, it's accepted that it's not included.
Yes.
The only defence that is advanced is to say, oh, but the operator told us it was included.
Mm-hmm.
And that's inadequate, and the reasoning of, I think, Justice Buchanan in phosphate resources in my submission encompasses that sort of thing as well. And Your Honour will recall the importance that the mine levy wall played wherever we may get to with the costs associated with the Western Perimeter Runoff Dam and the Southern Perimeter Runoff Dam. There's no submission made to Your Honour that the additional costs of the mine levy wall maintenance would be insignificant. In relation to the perimeter runoff dams, we'll of course figure out if this $81,000 figure is correct, but that line item is limited to a 2-year period.
Yes,
That is the complaint we make. That's the complaint we make in our submissions, that all of this infrastructure is limited to a 2-year period. So 81,000 times whatever to get up to however long it should have been maintained. But we do say that that's going to get to something significant. And then finally, Your Honour, Assessment Report 86. It's common ground that the Minister thought her decision was consistent with Assessment Report 86.
yes,
That contradicted the advice she'd been given on 2 separate occasions by her advisor that it was inconsistent.
but then she got contrary advice.
No, Your Honour, she did not. The advice that she was given in Appendix G, which is attached to her statement of reasons, is that it was inconsistent. That's what it says expressly. Now, they say it still meets they say they reach the view it still meets the overarching objective of protecting the river, but they don't claim there that it's consistent. And that's really the heart of the problem here, because the department has decided that there are problems with the EPA's recommendations because the EPA hasn't taken certain things into account, they say. Now, the consequence of that is not that one can conjure up a consistency. The consequence of that is that it is inconsistent, and they would say for good reason. Now, a conclusion that it's inconsistent, even for a good reason, is a very different one from thinking it's consistent. And in terms of the reasoning that they gave in relation to saying to why they decided to advise the minister to do what they did, is also itself incoherent. And that's because the EPA said you must not keep the tailings in situ. It poses too great a risk to the MacArthur River. That's what the EPA said. The department says, but your proposed solution of taking to the pit void has an unknown environmental outcome. So we can't do that. The water's not deep enough.
Means that you have to find a third solution.
It's incoherent, Your Honour, to say, all right, well, we've eliminated the EPA's proposed solution, so now we'll go back to the one that the EPA told us decisively was too harmful to the MacArthur River. It just makes no sense.
Yes, all right.
I can see Your Honour isn't enthused about the debate about who told what to the EPA,
No,
but Your Honour has my submission that they didn't tell anything to the EPA.
yes, you don't need to repeat any of those.
I'm grateful, Your Honour. And then, just in relation to futility,
Yes,
we of course, embrace any suggestion that declarations could be made. There is still utility in quashing these decisions if they're unlawful.
yes,
And that's because all of the subsequent decisions, even on the limited material before the court, are based on the decisions we challenge.
are they though?
Yes, Your Honour, because there are amendments to them. So there's been no new mining management plan. There have been 2 variations of the authorisation, and those 2 variations of the authorisation are based only on amendments to the unplanned closure plan.
Yes,
So all of these decisions in my submission are inextricably linked. Quashing the decisions we challenge here
brings the dominoes down.
brings the dominoes down. Those decisions have no effect.
Yes, all right.
Your Honour, those are my submissions.
Thank you very much. Goes without saying that I'm reserving my decision. We'll hand down a decision as soon as practicable, but I cannot yet give you a time frame.
Can I
Yes,
just
Mr.
ask,
Lloyd?
I just wasn't sure from what you said yesterday or this morning about speaking to MRM. Do you want us to give them a week to put on submissions or just a week to make any application they want to make?
I hadn't thought that through, and why a week? What we need to, so we're determined that they ought to be put on notice that they may make submissions or they may either apply to be joined or make submissions. So we're just talking about what they need to do within what time frame, that's right. So what are the suggestions? I'm happy to listen.
And can I suggest we notify
Yes.
them of this discussion and that we suggest that they make any application they want to make to be joined within a week, and then if they come along, they can say how long they need to.
All right.
Would be a bit harsh for them to have to make submissions within a week for a matter they don't.
Well, it might be, yeah. All right, that makes perfect sense. Mr, you're agreeing with?
Yes, Your Honour.
Yes. All right, thank you. Yes, thank you both. And I will notify you when I can hand down that decision. Right. Thank you. Please adjourn the court.
Silence all stand. This honourable court now stands adjourned.